The following videos were developed as a community service in partnership between the Unified Government of Wyandotte County and Housing and Credit Counseling, Incorporated, otherwise known as HCCI of Topeka, Kansas. Landlord Training, Module 4, Non-Renewals, Terminations, and Evictions. A series of 6 modules were developed by HCCI in Wyandotte County to address frequent issues that arise in the residential landlord-tenant relationship. The 6 module topics include rental applications, fair housing as it relates to tenant screening, crime-free multi-housing advanced management techniques, rental licensing and inspection, and this current topic, non-renewals, terminations, and evictions. Information discussed in the landlord-tenant modules can be referenced in the Kansas Residential Landlord and Tenant Act, otherwise known as the KRLTA, as well as federal fair housing laws. To learn more about HCCI and HCCI services, including landlord and tenant information, publications and forms, or if you need to speak to a landlord and tenant counselor, contact us at 800-234-0217 or 785-234-0217. You can also visit our website at www.hcci-ks.org. There are basically 3 ways a landlord may terminate a lease agreement. First of all, stating in writing the lease will not renew. Secondly, a lease can be terminated due to lease violation notices. And thirdly, a lease can be terminated by legal eviction proceedings in court, followed by a court order of eviction. In the following slides, each termination option and issue will be covered in detail. You can also contact HCCI to obtain copies of any notices discussed in the video. It is also important to note that just because a lease is not being renewed or a lease is being terminated does not constitute a legal eviction. A legal eviction is only a matter carried out in court. Delivery of notices covers all notices outlined in the KRLTA, which can be served to the tenant. You can hand deliver the notice to the tenant, but it must be hand delivered to a tenant who resides at the premises over the age of 12. Keep in mind, it might not be such a good idea to entrust such an important document to a minor, and also perhaps unfair to burden a child with adult business. The most popular way, and also probably the best, is to post it at the unit by taping it or tacking it to the door. This avoids confrontations, and if you're worried the tenant could say he did not receive the notice, you can take a photo of it hanging on the door using your cell phone. You can of course mail the notice, but if you do so, you must add 2 days, so if you're giving a 3-day notice for non-payment of rent, it must then be a 5-day notice. And if you're giving a 30-day notice of tenant non-compliance, if you mail it, you must give the tenant 16 days to correct the issue. If you're giving a 30-day notice to vacate, ensure the tenant receives it on their rent-paying date or even before, which is 30 days before you want them to vacate. You can mail it by first-class regular mail, which costs the price of a stamp. If you want proof of delivery, there are ways to do it. You can mail it certified, return receipt requested, meaning the tenant will have to sign stating they received it. This will cost approximately $6 or more depending on the weight of the notice or notices. This might not be the best option as the tenant may not sign for it. You can also mail it certified mail with electronic delivery confirmation, which costs about $5. With this option, you can go online at USPS.com to track when the tenant received the notice, meaning when it went in his mailbox. But the least expensive way to prove you have mailed a notice is to mail it via regular first-class mail and add USPS tracking at a cost of about $1. Once again, you can check the status of the tenant receiving the notice by visiting USPS.com, putting in your tracking number, and you will receive a confirmation of when the item was delivered to the tenant's mailbox. You can then print that confirmation off as proof of mailing. 30-day notice of non-renewal. This notice is simply stating the lease will not renew. The law says you must give the minimum of 30 days on or before a rent-paying date. However, you can allow more than 30 days in your lease. For example, you can give 60 days, though 30 is the norm. The notice must be in writing. It's never a good idea to give a reason for not renewing a lease. It's best that if the tenant asks why you're not renewing the lease, that you state it's a business decision. You don't want to get into a battle with the tenant or make the tenant feel they are being singled out, or give the tenant a defense to fight the decision in court. Just be matter-of-fact in your wording of the notice, and your wording if the tenant confronts you about it. As a side note, if you don't give any vacate notice before the lease expires, the lease by law then reverts to a month-to-month lease agreement. If this happens, then any time after that point, you can give a 30-day notice at any month, as long as it's on the rent-paying date. This is a sample 30-day notice of non-renewal. It simply states the tenant's names, the date, and that the purpose of the letter is to ask the tenant to move out of the property that they are renting from you. Put the address and the date you want them to move. Also, that failure to vacate will result in legal eviction action. That way they know you're serious. It is also important that you sign the notice. 14 30-day notice of tenant noncompliance. If there is a noncompliance by the tenant with either the rental agreement or a noncompliance with Kansas Statute 58-2555, materially affecting health and safety, the landlord may deliver a written 14 30-day notice to the tenant, noting the violation and informing that the rental agreement will terminate 30 days after receipt of the notice, if the violation is not remedied in 14 days. Always keep a copy of this notice. Kansas law says if the violation is remedied within 14 days, then tenancy goes on. In the previous slide, you were instructed you have the option to give a 14 30-day notice if the tenant is not complying with the lease terms, or Kansas Statute 58-2555. This statute states that the tenant must comply with the following: comply with building and housing codes affecting health and safety, keep the unit as clean and safe as the condition of the premises permits, remove from the tenant's units all ashes, rubbish, garbage, and other waste in a clean and safe manner, keep all plumbing fixtures in the unit or used by the tenant as clean as their condition permits, use in a reasonable manner all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities and appliances, including elevators in the premises. Be responsible for any damage or destruction or any removal of any part of the premises caused by the tenant. This also applies to any actions by any guest of the tenant or any actions by any animal the tenant or their guest has allowed on the property. The most commonly cited reasons for giving a noncompliance notice are poor housekeeping, unauthorized pets, improper use or destruction of the property, guests who stay, and nuisance or noise. As a side note, in reference to nuisance or noise, do not allow a tenant or their guest or a tenant's pet to continually engage in conduct that will disturb the quiet and peaceful enjoyment of other tenants. Instead, start the process to get rid of the perpetrator. Ignoring nuisance and noise will eventually cause you to lose good tenants. If after the 14-day period there is a same or similar occurrence, the landlord does not have to give another 14 30-day notice. So, for example, if the tenant receives a 14 30-day notice for an unauthorized pet and then gets rid of the pet within 14 days, then tenancy goes on. However, after the 14-day period, if there is a same or similar occurrence, in other words, if the tenant brings another unauthorized pet into the premises, the landlord does not have to give the tenant a second chance to correct the issue. The landlord can simply give a 30-day notice to the tenant in writing. They should state the reason and keep a copy. The notice must state the tenant must vacate 30 days from receipt of the notice. If the lease terminates due to a 14 30-day notice, Kansas Statute 58-2564 says the rental agreement terminates. If the lease terminates, the lease has ended, and nothing in Kansas law says a landlord can continue to collect rent once a lease has ended. 3-day non-payment of rent. Kansas law says the landlord may terminate the rental agreement if rent is unpaid when due and the tenant fails to pay rent within 72 hours or 3 days, not business days, after written notice by the landlord of non-payment. If the landlord mails the 3-day notice, they must give 2 additional days. The tenant also has the option to vacate within 72 hours, which is removing all belongings and hopefully cleaning the unit. The lease terminates and the tenant avoids legal eviction. You can give more than 3 days to pay, but 3 days is the minimum and the most common used by landlords. To break it down, if rent is due on the 1st and not paid on the 1st, then on the 2nd, the landlord can give a 3-day notice of non-payment of rent to the tenant. If the tenant has a grace period for rent, such as rent is due on the 1st, but late if not paid on the 5th, then the landlord cannot serve the 3-day notice of rent non-payment until the 6th day of the month. To sum it up, if the tenant does not pay the full amount due within 72 hours, the landlord can begin with legal eviction. A tenant does have another option when receiving a 3-day pay or vacate notice. A tenant might not be able to come up with the rent money within 3 days, so that tenant has the option to vacate. The tenant should turn over the keys to the landlord. If the tenant vacates within 72 hours, then the landlord should not proceed with legal eviction action. The tenant will still, of course, owe the landlord rent money, but the landlord has the option to take the tenant to small claims court to recoup those monies. The 3-day notice of non-payment of rent must be in writing. It is important the date and time the notice is delivered is stated on the notice, because the tenant is given 3 days or 72 hours to vacate from that date and time. Also state the amount owed, as well as the fact the landlord intends to terminate the rental agreement if the rent is not paid in full by the 72-hour deadline. Within the 72-hour time frame, if a tenant pays in full the amount stated on the notice, then tenancy goes on. If the full amount is not paid within 3 days, or the tenant does not vacate within 3 days, then the landlord can proceed with legal eviction action on day 4. This is a sample of a 3-day notice. This notice can be handwritten, typed, or in the format of a form. It is also important to save a copy of the filled out notice. You will want to save a copy of the notice as proof you followed the first step in the eviction process. The copy will be given to your attorney, or you can use it to present to a judge if you represent yourself in court in an eviction action against the tenant. Regarding the 3-day notice to pay or vacate, if a tenant attempts to pay within a 3-day period and pays the full amount, then tenancy goes on. However, if the tenant attempts to pay within the 3-day period but not the full amount, if a landlord accepts the money, he should give the tenant a receipt stating accepting late rent but reserving the right to evict because rent was not paid in full within the 3-day period per statute 58-2564B and 58-2566. Also, if the tenant pays after the 3-day period, either part of the rent money or pays in full, if a landlord accepts the money, he should give the tenant a receipt stating accepting late rent but reserving the right to evict because rent was not paid within the 3-day period per statute 58-2564B and 58-2566. In these situations, sometimes landlords are unsure whether to accept payment at all, fearing they may not be able to evict or that the eviction might be thrown out of court if they accept the money. Therefore, a landlord should consult with his attorney regarding such circumstances. This is a sample receipt reserving the right to evict. This notice is stating the landlord accepts the money paid to them and the date it was accepted, that they are reserving their right to pursue legal eviction. This amount was paid after the due date and/or a partial payment of the amount owed. In accordance with KSA 58-2566, this is to advise the tenant the landlord does not waive his right to terminate the rental agreement for the tenant's failure to pay rent on time and in full. Continually accepting late rent can waive your right to evict per statute 58-2566. Kansas law says acceptance of late rent from the tenant that varies from the terms of the rental agreement constitutes a waiver of the landlord's right to terminate the agreement for that breach. Accordingly, it is never a good idea to accept late rent on a continual basis. The statute is stating if a tenant is late paying rent, A landlord should not wait to serve a 3-day notice to pay or vacate, nor should he wait to follow up with legal eviction proceedings if the tenant does not pay in full within the 3-day period. The longer a landlord waits, the more money he loses and could also be waiving his right to evict. Keep it business professional. The tenant wants to be paid on time where he is employed, and a landlord should also require to be paid on time and in full. Retaliation in the form of non-renewal of a lease or a legal eviction. Since eviction action is being discussed, let's cover the subject of retaliating against a tenant. A tenant may be paying rent late, or on the contrary, may be paying in a timely manner. In either scenario, tenancy has gone on without incident until a tenant calls code enforcement to report a maintenance issue a landlord has ignored. When the landlord finds out the tenant called code enforcement, he becomes irritated and so suddenly decides to end the lease agreement, either by non-renewal of lease or by filing a legal eviction for late payment of rent when the landlord has always ignored late payments in the past. Per Kansas Statute 58-2572, this could be considered retaliation and could be used as a defense in court by a tenant for eviction action. Eviction the right way, the legal way. The landlord begins with proper written notice, a written pay or vacate notice giving the tenant 72 hours to pay or vacate. A case is filed in district court. There's a court action. Only courts can legally evict. There's a judgment for the landlord. A court order carried out by the sheriff's department or process server. Eviction the wrong way, no court action. This is also known as unlawful removal or a self-help eviction. This is when a tenant is late paying rent and the landlord locks them out of the property or physically removes them by threat or by force. A landlord in such a situation might throw all the tenant's property away or lock it up and remove it and store it. A landlord also would be performing unlawful removal if he turns off the utilities. Even if the landlord puts the utilities in his name, he cannot shut them off. All of these scenarios are illegal. If the landlord proceeded with unlawful removal, then the tenant has recourse. The tenant may demand possession or terminate the rental agreement. In either case, recover actual damages or 1 1/2 times periodic rent, whichever is greater. The tenant can also call the police. They may intervene for the tenant. The tenant can file charges of theft or criminal deprivation of property. A landlord can legally evict a tenant if the tenant is given a 30-day notice of non-renewal and does not move, or a tenant is served a 14 30-day notice of lease termination but does not correct the issue and does not vacate in 30 days. Or if the tenant is given a 3-day notice of rent non-payment and does not either pay or vacate within 72 hours. As mentioned previously, it is important to keep a copy of any such notice served to the tenant, as well as the lease agreement and other applicable documentation which may be needed in a legal eviction court action. A landlord can contact an attorney to represent him in court or even evict pro se. Once again, pro se means self-representation in court. Eviction paperwork can be found at the link shown on the slide. Follow this website to obtain the forms needed to legally evict a tenant. HCCI does not explain the step-by-step legal process to evict in court pro se, but will give the general outline. The entire eviction process typically takes about 3 to 4 weeks from start to finish. This is why a landlord should not waste time if eviction becomes necessary. The longer time is wasted, the more money it will cost in the long run. Eviction pro se, or eviction with attorney representation. If evicting pro se, make sure all forms are filled out accurately and completely, and that the proper number of copies are made for the court. Also, some forms may be designated to be signed only in front of a notary public. Check for those forms and only sign in front of a notary public. Make notes before you go to court so you are prepared and know exactly what you want to say. Be prepared to provide any information requested by judges and court staff. Remember, the judge cannot speak to you about your case, except when your case is in court and when the other party is there. Court staff can help you with questions such as where your hearing is scheduled or if you're in the right courtroom, but they cannot give you any legal advice or recommendations about what you should do or how you should fill out a form. If you don't feel comfortable representing yourself or it is new to you, then you may decide to use an experienced attorney who will do all the work for you and represent you for your best interest. Docket call of the court. Once the eviction suit is filed, the attorney or the landlord representing himself pro se will be provided a date and time for the docket call of the court. The tenant will then be served notice to appear in court. At the docket call, if the tenant appears, they will be asked whether they agree, disagree, or no contest that they owe the rent. If they agree they owe the rent, then they will lose and be told when they must vacate the property. If they say they disagree, they will be given a court date. If the landlord or the landlord's attorney does not show up for court, the case will most likely be dismissed. If a landlord or his attorney show up, but the tenant does not show up for court, the tenant will lose and will be evicted. It's important to note that court processes vary across the state of Kansas. As stated previously, if the tenant says he disagrees he owes the rent, then a trial date is set. At trial, the landlord and the tenant will present any evidence. A judge will listen to both sides and make a ruling in accordance with the law. The judgment will depend upon what is listed in the petition. Usually this will be any back rent and possession of the specific premises. The tenant has 5 days after judgment is entered to file an appeal and a supersedeas bond. If the tenants do not vacate by the date given by the court, the Writ of Restitution, also known as the Writ of Removal, is an official court document that directs and orders the Sheriff's Department to immediately remove the occupants of the specific premises, inventory the property located there, and turn the possession of the property to the landlord. Entry of the premises may be by whatever means necessary to effect the court order, including the use of a locksmith. Costs for entry will be paid by the landlord. Prior to the sheriff executing the Writ of Restitution, a notice is delivered to the tenant or posted to the premises stating that the sheriff's office has a court order to evict the tenant. The notice states a specific date that the sheriff's office will effect the court order, which means force the tenant to vacate. This is a courtesy only as a notice and is not required by law. This notice is given to allow the tenant one last chance to move on their own. The eviction or Writ of Restitution can only be canceled by the courts, the landlord or the landlord's attorney. Once the sheriff shows up, she will typically only give the tenant approximately 10 minutes to gather emergency items such as medications and get out. On the day of eviction, the landlord should be prepared to meet the sheriff at the door and change the locks. Also, if the tenant left any property in the unit, the landlord should be prepared to store the tenant's possessions. Abandoned personal property. The landlord gains possession when a tenant moves out, surrendering the rental unit and leaving behind personal property, or when there's a legal eviction action and the tenant's property is left in the unit after the tenant is forced out. The items can then be stored in the property or in some other type of storage facility. It does not have to be a professional storage facility. It can be the landlord's garage. The tenant's items must be stored for 30 days and a process must be followed. Keep in mind that storage of the tenant's possessions includes vehicles and animals. If they have animals at the time of eviction and do not intend to take them, the landlord is responsible for boarding or otherwise keeping them for 30 days. The abandonment process. The landlord must store the tenant's personal property for 30 days, publish an ad in the local newspaper in general circulation 15 days before the disposal of the property. Send a copy of the ad to the tenant's last known address within 7 days the notice appears in the paper. Release the property if the tenant can pay within the 30-day period before the disposal date. Release secured property to a legal owner, for example, Rent-A-Center. The notice is not only so the tenant might see their property is being held, but for also companies that might have rented items to a tenant, such as a Rent-A-Center. If such a company brings paperwork to a landlord showing they own, for example, a rented television, the landlord must release it to that company. Here's a sample of an abandoned items notice. Abandoned property. Include the tenant's name, the address of the rental. All possessions stored will be disposed of if not claimed, and include the due date. Also include the name or contact number of the address of whom to contact. If the tenant pays all that is owned in the 30-day period, then items must be returned to the tenant. After the 30-day period, if the tenant has not paid all owed, the the landlord may dispose of the tenant's personal property. It is extremely important that this process is followed. Otherwise, the tenant has a right to sue for damages he has sustained because the landlord did not follow the proper process. Evictions can be complicated. If uncomfortable with the process, it may be a good idea to hire an attorney. It would be best to locate an attorney familiar with the eviction process. Need more answers? Free answers are available by contacting HCCI at 800-234-0217 or 785-234-0217. You can also visit our website at www.hcci-ks.org.